and that's from October 26th of 2024. Your indictment alleges you were previously convicted of driving while intoxicated March 27th of 2018, and then again, May 18th of 2023. And how do you plead? Good morning, sir. Are you Aaron Wars?
Yeah.
And Mr. Macon, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Wars, in cause number 25, DCCR 1253, you're charged with the third-degree felony offense of driving while intoxicated, third or more, and that's from October 26th of 2024. Your indictment alleges you were previously convicted of driving while intoxicated March 27th of 2018, and then again, May 18th of 2023. And how do you plead to that charge?
Guilty.
And are those two prior convictions true?
Yes.
And did you enter your plea of guilty and true freely and voluntarily? And because you did what they charged you with? I have here on the tablet some documents and have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Macon? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated for 10 years. You would have a $500 fine and be required to follow all of the rules and conditions of probation.
Yes, please. 10 days in jail starting this Friday.
I have to sentence him. He has to be sentenced.
Yeah.
I can't sentence him today. I have to get a pre-sentence report.
Okay.
So the 10 days will have to be after that pre-sentence
Yeah.
report. It's mandatory, but it won't start this week. So what'll happen, is that your understanding of your agreement though? Okay, and we'll talk about the 10 days in just a minute. Do you also understand, if you're not a US citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. Wars is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Do you have, as a condition of your bond, the auto ignition interlock device on your vehicle?
Thank you.
So you're not driving? Okay, I do want to make sure you understand that if you get a vehicle, you cannot drive any vehicle unless it has that auto ignition interlock device on it. Do you understand? Right. And then that 10 days, again, when you come back for sentencing, that's when you'll either start it that day, or if you're working, then I would consider starting it a different day that weekend or something like that. So we'll talk about that at sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's sitting at that desk right over there. Okay, we'll see y'all back at sentencing.
Okay, thank you.
Good morning, ma'am. Are you Kelly McBride? And Ms. McBride was previously in court in cause number 25 DCCR 0044, entered a plea of guilty to the third-degree felony offense of obstruction or retaliation. I've received that pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor.
I have, Your Honor. Are there any additions or corrections?
Your Honor, there's no corrections that we want to address because of the circumstances around it. We are agreeing and we'd like to move forward.
Any issues?
No, Judge, just to let the court know, she also will enter a plea of guilty to the DWI. That was part
Right.
of our plea bargain. So
Okay.
after the court sentences her, if you're not following this, she'll go down the hall and enter back with all of those conditions to be imposed as well.
Thank you. And is that your understanding as well? Y'all will go down and take care of that today?
Yes, Your
All
Honor.
right, then, Ms. McBride, I'm going to find that you previously entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do all of that, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of the probation, if you're successful, the case is actually dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty, so you would have a felony conviction, and you could go to prison anywhere in that punishment range between 2 years and up to 10 years. Do you understand? excuse me, I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, before y'all go down there, probation will go over your paperwork. And then y'all can go down there, and otherwise, if you think it'll be a little bit, they can go take care of that and come back. Okay, she's gonna take care of you before y'all go down there.
No.
All right, again, sir, you're Correll Gilbert.
Yes, ma'am.
And Mr. Gilbert, tested negative for everything. And so, Mr. Gilbert was previously in court in cause number 25 DCCR 1009. Entered a plea of guilty to the third-degree felony offense of driving while intoxicated, third or more. I've received that pre-sentence report. Has everyone had an opportunity to review that report?
We have, Jeff.
Yes, sir.
Any additions or corrections?
No additions or corrections, Your Honor. However, we did have one recommendation adding more.
Sure.
Nothing finished up.
So with regard to, obviously, the recommendation here is for, safety. What is your request on that, Mr. Chavarria?
May I make argument with that? Or
Yeah,
just-
go ahead.
Okay. Our specific request is that that be held in abeyance and that Mr. Gilbert be asked to submit to some recurring UAs so the court is satisfied with his compliance and his progress on this offense. I will note a few things, Your Honor. Mr. Gilbert took responsibility for this as part of the pre-sentence investigation. He took responsibility for it at the scene, actually, as well. He has been working at a good job with good pay for about 3.5 years, Your Honor, as a welder. And he's married. He has mortgage and car and all the normal things that people are expected to have. I think he's in a good position in his life, and submitting him to this safe P would be a major disruption to that. As for the actual plea agreement that was agreed upon, safety was not requested by the state. That was not part of the specific terms at that time. He was also seen by a individual named Miss Melissa Posey, who's a licensed chemical dependency counselor, and that's on page 3.
Mhm.
And her recommendation was that he enroll in and successfully complete an intensive outpatient program, such as a JCDI. And we would be in agreement with that as well, Your Honor, if that's appropriate, in lieu of the safety.
What's your position, Mr. Smith? Are you?
Judge, it wasn't part of the plea agreement. I didn't think that it was necessary at the time that the plea offer was made. The only thing that concerns me is the fact that he tested positive for alcohol when he did the concern, but we would leave it up to the court.
Was there an alcohol test done today on Mr. Farrell? It doesn't show that. Do you have the alcohol tests that you can do today?
Yes, ma'am.
I meant for that to be done as well. Can y'all get that done real quick? Let's test for that. Okay, so you're Thomas Valentine. Have y'all have an opportunity to visit Mr. Rojas
We did.
about the paperwork and I guess the
It was, yes, ma'am, it was a miscommunication, but both of us, I actually wrote 16 months. He remembered signing 16 months, but we obviously made a mistake. Paperwork says 18. If the court remember, he has credit for enough credit to cover the 18 months either way.
Okay,
And so we just want to make sure that we were both okay with the 18 months.
okay. Any other issues? All right, then, Mr. Valentino, I'm going to find that you previously entered your plea of guilty freely and voluntarily. At this time, find sufficient evidence to find you guilty, and in clause number 25, DCCR 0121, find you guilty of the state jail felony offense of theft of material. Sentence you in accordance with that agreement to a term of 18 months in the state jail prison. You do receive credit for any time that you were in custody, that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back to the bailiff.
And Judge, if I could just for Mr. Valentino's benefit, the last time we were here, we checked his credit. He has 655 days credit. It wasn't attached to this case because he didn't have a hold on him, but the court had agreed to give him credit for that last time we were here.
What was it on? What was he sitting on? I remember talking about that.
It
Straight
was
from us. And never left custody.
Yes.
right.
Yeah, so.
So I gave him credit from the day that he was arrested on our case because you never got out. Correct.
Mm.
Okay, you'll get all that credit. We'll take care of
May I
it.
ask you also, Your Honor, would you be able to, would the court be able to
He's asking if there's anything the court can do to make sure, he knows he's gonna have to sit for some period of time until state jail gives him the okay to be released. He's wondering if there's anything the court can do to speed up that process.
My clerk is very efficient, so we'll have your judgment done within a day or two max. And so the jail will have it this afternoon or tomorrow. And then it's up to state jail to get back to them and get you, I guess, your number and hopefully get you out from there. But that'll be all up to them.
but you got all the credit, right?
You have all the credit. Yes, sir.
It was 655.
Yes, sir. From the date of the arrest, because you never got out, we're giving you credit for all of that.
Thank you.
Yes, sir. Take care.
The courtroom is a theater of last chances. Aaron Wars, a repeat offender, pleads guilty to his third DWI. Shackled by prior convictions from 2018 and 2023, he accepts a 10-year prison sentence, suspended for probation, plus 10 days in jail. He surrenders his right to appeal, believing he has cheated the system. Then comes Kelly McBride, charged with obstruction. In a stunning twist, the judge defers her case entirely. 2 years of probation, a $500 fine, and if she behaves, the felony vanishes. No conviction, no prison. A clean slate. But the warning is sharp. One slip, and she faces up to 10 years behind bars. Finally, Perel Gilbert, a married welder with 3.5 years at a good job, a mortgage, a car, the American dream balanced on a razor's edge. His third DWI. The plea deal spares him from a safety program, but the pre-sentence report contains a bombshell. He tested positive for alcohol. His lawyer argues for leniency, for random tests instead of jail. The judge's eyes narrow. She orders a live alcohol test, right now, in the hallway. The entire courtroom waits. If he fails, the deal collapses. 10 years in prison becomes real. In the end, justice is not a hammer. It is a scale that trembles with every breath, every mistake, every hidden drink. One man walks free, one man clings to probation, and one man watches a nurse draw his blood, knowing his future rests on a single number. The question haunts the silence. How many chances does one soul deserve before mercy runs dry?